waiting to
Well, I
hear
hope that I can live
your
up to
words.
everything that you've said. I'd like to see is the presentation up? I don't see it.
There you go.
There we go. Okay, so very good morning to everybody, and I hope that everybody's feeling well today. We're going to discuss, and from my perspective at least, cryptocurrency and virtual assets from a U.S. compliance perspective, specifically income taxes and certain fraud situations that have occurred, violations of U.S. Securities laws, and so on. So if we can go on to the first slide, I would appreciate it. So let's start with the U.S. tax system. The U.S. tax system is unique. It's one of only two countries in the world which requires all of its residents or people that are permitted to reside in the U.S. to report all of their worldwide income. This includes U.S. citizens, permanent residents, wherever they live, people that are here a certain number of days per year or over a 3-year period. And they not only have to report all of their income, next slide, please, but they also have to also report their financial assets worldwide. Could I go to the next slide, please? So with respect to virtual assets, which some people call cryptocurrency, in the United States, crypto is not a currency. And in many countries, it's not a currency. And under U.S. definitions of currency, it would have to have been something that was created by and put out by the government to be used as currency. So in the United States, crypto and virtual assets are basically just capital assets or other assets which are used for trade and business. FinCEN, which is the Financial Crime Center of the United States, has a focus on knowing your customer and all the parties involved in these transactions. As a result, it has designated cryptocurrency exchanges as money service businesses that are required to register with FinCEN. And it has established bookkeeping and record-keeping requirements for convertible virtual currency. And I say virtual currency in quotations because I want to keep saying that virtual currency in the United States is not considered legal tender. It also has included, however, legal tender digital asset transactions in excess of $3,000 in its reporting regimen. What are legal tender digital asset transactions? Are transactions in which digital currency is either received or exchanged for other assets. The Anti-Money Laundering Law of 2020 expanded the Bank Secrecy Act definitions to include all virtual assets in these categories. And for this purpose, it now requires a value transaction report for transactions in excess of $10,000. And this is very similar to the currency transaction reports that we have in the United States, and it's also similar to the FBAR. However, the one thing it doesn't address is transactions between unhosted wallets, because they are not considered to be custodial or bank accounts. They are privately held between people. The Office of the Comptroller of the Currency permits banks to offer custody services for virtual assets or cryptocurrency assets. That's something relatively new. Most banks with which I'm familiar don't offer that at the moment, whether they're in the United States or out of the United States, because whenever we're talking about virtual assets, we're talking about an asset sitting in custody that's essentially like a chip in a casino, and depends on how value moves up and down. Just like in the stock market, its value can change. So if a bank is going to do this, it has to be very sure of the bet that it's making by allowing it, by custodying these assets in its location. The CFTC, the Commodities Futures Trading Commission, in the United States has also taken a stake in this, as has the SEC. And it treats these virtual currencies and virtual assets are commodities if they are related to commodities derivatives. The Securities and Exchange Commission says that they're securities subject to regulation and registration, and we'll talk a little bit more about that further on. Next slide, please. So here's where we get into what is a security, okay? We're talking about something called the Howey test. This was a Supreme Court case in the United States, and it determined whether a transaction would qualify as an investment contract. And under this particular test, an investment contract exists if there is an investment of money in a common enterprise with a reasonable expectation of profits to be derived from the efforts of other people. This applies to any contract, scheme, or transaction which can be incorporated into this test. So in thinking about this test, a cryptocurrency token, or a virtual asset token is a security if the holder makes an investment of money in a common enterprise with the expectation of profit to be derived from the efforts of others, meaning the trading of these particular tokens. There was a 2017 case called Dow Tokens, in which the SEC, the Securities and Exchange Commission of the United States, ruled that the sale of Dow tokens for Ether, which was a major cryptocurrency at one time, it still is, violated U.S. securities law. And as a result, most ICOs, which are initial coin offerings today, are now off limits to U.S. investors. Next slide, please. I want to talk now, back up one, please. Back up one slide, please. The Telegram Group. This was a 2019 case, and it highlights the need for everybody who's involved with this to ensure compliance with U.S. federal securities law. The Telegram Group and its subsidiary, TON Issuer Inc., began raising capital to finance the companies, meaning both companies' businesses, including the development of their own blockchain called TON. And there are other people that can talk about blockchain, but one of the benefits of blockchain is that it's indelible and can't be erased. And it's also one of the negatives for people that want to be criminals because it can't be erased. It can be traced. In this case, the entities involved sold $2.9 billion in digital tokens, which they called grams, worldwide, including to 39 U.S. purchasers without registering with the SEC. And in that case, a federal judge ruled that the activity was part of a larger scheme. If you remember the Howey test, it was a scheme to distribute the grams into the secondary market. And the court ordered Telegram to disgorge, I should say, $1.2 billion of the money that it raised and levied a civil penalty of $18.5 million against the Telegram Group. Next slide, please. So what is the IRS treatment of virtual assets? In the United States, under the IRS regulations, virtual currency is treated as a property for federal income tax purposes. So when one sells virtual currency, there's a gain or a loss that is required to be recognized, just like with stock or any other security or any other asset. Virtual currency received as wages is also taxable as wages from employment, can be taxable as capital gains, and it can be taxable also as dividend when you receive it, for example, as a distribution from a corporation. Purchases and sales in exchange for virtual currency are subject to taxation on the difference in value. The Build Better Back Act of 2021, which was something that was passed during the beginning of the Biden administration, contained language that made the wash sale rules apply to cryptocurrency. However, it didn't pass the Congress, which means that wash sale rules don't apply, and that's a benefit to people that buy and sell cryptocurrency. And wash sale rules basically say that if you buy and sell something within 30 days, certain losses are not permitted. I want to talk for just a minute about the concept of virtual currency being exchanged for other assets in the business context. If a business receives virtual currency, for example, a car dealer in exchange for the sale of a car, that is an ordinary income item to that dealership. It's a normal sale. And that virtual currency at that time, as a result, is treated as having the value of the asset for which it was used to purchase. So if a car is sold for in the United States for, let's say, $20,000, and it's exchanged for $20,000 in crypto or virtual currency, that virtual currency at that point has a value of $20,000. If there was a difference in value prior, then there would be a sort of an adjustment that would have to be made for tax reporting in the US. It's complicated. In 2021, the Infrastructure Investment and Jobs Act established that persons who transfer digital assets on behalf of another person are considered brokers. And beginning in 2025, a U.S. Form 1099 DA for digital asset must be provided annually for those types of transactions. That means that centralized exchanges of digital assets, cryptocurrency, must now track every purchase and sale of cryptocurrencies, including basis, selling price, and profits or losses. Next slide, please. So how does IRS in the United States deal with this? We have a tool in the United States called a John Doe summons. John Doe is a name, could be anybody. It's just a generic name that we've devised in the United States. And a John Doe summons is a tool used by the IRS to target as yet unknown taxpayer targets. In other words, when the United States decided to look at Kraken and Circle Internet Financial, it issued those entities a John Doe summons for the names of the people who were trading through their particular organizations. And how this is done is IRS goes to court, obtains a court order to compel information from a third party, such as a crypto exchange, concerning a taxpayer who's not yet identified by the IRS by name, because after it receives the records, it will then begin to identify targets that it wants to audit and investigate to make sure that they're reporting all of their income. So in Operation Hidden Treasure that I just mentioned, IRS enforcement, which was an IRS enforcement initiative for tax violations related to cryptocurrencies, it used these John Doe summonses, and it sought data on the customers and transactions that were occurring in those two organizations. The IRS has been telling the U.S. taxpayer since 2014 exactly how they want this stuff reported. And there has been some hesitancy on the part of the public. And so beginning 2 years ago, a question appeared on all U.S. tax returns relating to whether or not these sorts of transactions have occurred. The failure to properly answer those questions can result in an inaccurately filed tax return, or answering them incorrectly makes it obviously inaccurate. And the IRS in the United States would then have the opportunity to use those types of filings to charge a taxpayer with either a misdemeanor or a felony, or otherwise penalize the taxpayer for the failure to report accurately. Next slide, please. So we now have these newer IRS efforts to promote compliance. We had a large exchange called FTX, which was deemed to be a giant Ponzi scheme. And it would involve billions of dollars. And so it created, in and of itself, new incentives for regulation. This has occurred various times in the United States history where certain large actors turn out to be criminals, and that gives the government the cover, the shield, to be able to then impose new regulations. IRS issues soft taxpayer reminders to encourage virtual asset transaction reporting. What they will do is they will issue a letter to various taxpayers who they believe should be reporting and saying, please correct this so that we don't have to go through an audit. And the reason for that is an audit is costly. And if the government has to invest money in an audit in order to collect taxes that it should be collecting under US law, the government has an opportunity to also make examples out of people and charge them criminally depending on the amount of money involved. The IRS has an ongoing campaign. It's one of about 50 campaigns that it's involved with. And this particular campaign is set up to enforce virtual asset transaction reporting. It addresses noncompliance through multiple treatment streams, including outreach and examinations or audits. This also includes these soft reminders, and periodically it makes an example out of a taxpayer, and they become charged with a crime, and then of course the penalties increase because it can involve incarceration or jail time. Next slide, please. More recently, there's been coordination with the OECD and CARF. In October of 2018, the Financial Action Task Force, known in Latin America as GAFI, clarified that its 40 recommendations apply to virtual assets and virtual asset service providers, or VASPs, as well. In October 2021, there was a notice called Virtual Assets Service Providers, or VASPs, that describes the application of the Financial Task Force recommendations, clarifies that all of the funds or value-based terms in the Financial Action Task Force recommendations include virtual assets, explains the VASP registration or licensing requirements, and makes clear that only competent authorities and not self-regulated bodies can act as VASP supervisory or monitoring bodies. In other words, these organizations that act as cryptocurrency exchanges are not going to be permitted to self-police. They are required now to be regulated. VASPs and other entities involved in virtual asset activities should apply all the preventive measures described in the FATF recommendations 10 to 21, including thresholds for occasional transactions, the travel rule, and customer due diligence. And then for those that are not familiar with the travel rule and the implications of this October 2021 notice, the travel rule was promoted as a Bank Secrecy Act rule. It was promulgated that requires financial institutions to share specific information with other financial institutions when funds are transferred between them. This rule applies to both banks and non-banks. So because under FinCEN regulations, crypto exchanges are also considered financial institutions for this purpose. And it includes principles of information sharing and cooperation. Next slide. So on August 22nd, in August of 2022, the FATF approved the Crypto Assets Reporting Framework, or the CARF. The United States is coordinating with this as we sit here. And this requires standardized processes for the automatic exchange of tax information related to cryptocurrencies. In the same way that CRS acts as the FATCA for the rest of the world, the CARF acts as another version of CRS for purposes of crypto assets reporting. It requires identification of individuals, entities, and their controlling persons, and ensures that indirect investments in crypto assets through investment vehicles and derivatives are also covered by CRS. In other words, it's very, very difficult to run and hide once these regulations are put in place and countries adopt them. In October of 2022, the European Parliament approved the MiCA regulations, which are markets and crypto assets regulations, and the travel rule. Both regulations provide for a harmonized crypto regulator framework across the EU. So what is beginning to happen is around the world, the governments are recognizing that these particular transactions involving quote unquote cryptocurrencies are really transactions involving an exchange of assets. And if there's profits involved, those profits have to be taxed. And it's become a worldwide movement. And it's part of what we like to call the convergence of regulatory authorities worldwide to help and assist each other. And so the United States is participating in all of this also. Not in CRS directly and not in CARF directly, but through other methodologies that are being set up in the United States, such as BOI reports, which is beneficial ownership information reports with FinCEN and the AMLA law of 2021 for the exchange of information between financial institutions, not just banks. Banks are only one form of a financial institution under BSA regulations in the United States. Next slide, please. And thank you for all of this. Here for questions. I can tell you that we are seeing more and more audits of cryptocurrency in the United States. If there are folks in the audience who themselves have more than one citizenship or double citizenship, which includes the United States, it's important for you to be aware of what's happening with the U.S. situation. It has become more and more dangerous to not report crypto asset transactions, which includes the acquisition of them now. You're now required in the United States to tell the government whether you've acquired or whether you've sold or whether you hold these crypto assets. Are there any questions?
That is precisely what I wanted to ask Stanley. If there are any questions, of course, you can ask them in Spanish. Stanley speaks great Spanish, and otherwise we have our wonderful translator, Pato, who is interpreting simultaneously. So please feel free to ask your questions at any time in any of the two languages. Stanley is here with us, and he will stay for a bit longer, so please feel free and comfortable to send any of the questions you consider, and we're going to share them with Stanley so that he can answer before the module's over. Okay, thank you, Stanley. Always a wonderful presentation. This is such an important issue regarding taxes and everything that has been happening. We have spoken in previous modules about the travel rule, about MiCA as well. We also had Jana Hanaseva in the previous module speaking about European regulations and everything that you have just mentioned. So this has been a very interesting wrap-up. Thank you. Thank you. I really appreciate having had this opportunity to share this information with the audience. Thank you very much, Stanley. We are year after year seeing this great need of for training, for sharing information, and year after year you have seen and you have been with us. We see new subjects being added. So I'm very, very thankful for having you here with us. And thank you also to Etty. It's been a pleasure. Okay.